Assalamualaikum warahmatullahi wabarakatuh. My name is Aiman Syahira binti Osman and I'm from TLB 11. So today I will discuss about our case, which is Perwira, Affin bin Bhd and Saad bin Abdullah and another, 1999. Okay, so the fact of the case is first of all, there are defendant and plaintiff. Defendant is Saad bin Abdullah, which is known also as the charger in this case, and the plaintiff is Perwira Affin bin Bhd, which is the chargee. Okay, so in this case, defendant, which is Saad, is the registered proprietor of a piece of land, and the defendant had created the first legal charge, which is to secure the banking facilities to Saad Sdn Bhd, which is the borrower, up to the sum of Rm 80,000 together with interest. Then defendant create second legal charge to secure the banking facilities up to sum Rm 50,000 together with the interest thereon. And then the borrower, which is the company Saad Sdn Bhd, had defaulted on the repayment of the banking facilities. So plaintiff, which is the chargee, has sent a notice in form 16D under section 254 of National Land Code, which is the form 16D is the notice of default with respect to a charge. Okay, and after plaintiff had sent a notice, there is no response in relation to the form 16D from the defendant. So the plaintiff had made an application for an order for sale of the land. So defendant submitted that the form 16D was invalid because the sum claimed and the specified in it was not the sums secured under the two charges, and the alleged claim of principal and interest clearly exceeded the sums secured under the terms of the charge annexure.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Nurmunti binti Harun. I'm from TLB 11. Okay. I will talk about the issue of this case about the Perwira Affin Bank. The issue in question is about whether the statutory notice in form 16D constitute a valid demand pursuant to the issue of the charge in the question. Okay, alright. We need to look at several provisions in the National Land Code, such as Section 253 Clause 1 National Land Code said this provision enable the chargee to obtain the sale to which his charge relates, that in the event of breach by charger of any agreements of his part, expressed or implied, then okay, in the Section 254 Clause 1 of National Land Code laid down the three requirements that need to be fulfilled in order to exercise the power of sale. Okay, the first one is breach of covenant under the charge in the question. The second one is the notice before application for an order of sale. The third one is the breach of continued for 1 month. Okay, in this case, Form 16D said we need to specify the breach in question, but in this case, Perwira Affin Bank, the plaintiff did not specify the breach in question of the defendant. Therefore, the court made a decision to dismiss the application by the plaintiff because it did not fulfill the requirement of provision of Section 254 in the National Land Code, which is in the Form 16D, the plaintiff did not specify the breach in question of the defendant. Furthermore, the judge dismissed the application because the total sum of interest demanded by the plaintiff was wrong, because the two charges had exceeded the amount which is the defendant supposed to pay back to the plaintiff. Therefore, the judge dismissed the plaintiff application. Thank you.